When you thought Trump couldn't get any more pathetic in the motions that he files in the various courts, well, let me introduce yet another exhibit here. So in the Manhattan District Attorney criminal case against Trump, which is currently scheduled for trial on March 25th, we previously reported that Donald Trump requested a last-minute adjournment claiming absolute presidential immunity. Judge Juan Merchan responded, trial's 2 weeks away. Why are you even filing this ridiculous thing before my office? In any event, Manhattan District Attorney will give you the opportunity to respond. But Trump filed something else just now. He filed notice to the court that he intends to rely on a not formal advice of counsel defense. So Trump says he will be introducing evidence to blame his lawyers for his criminal conduct that's being alleged by the Manhattan District Attorney. But he's not formally making an advice of counsel defense, which if you make a formal advice of counsel defense, that would constitute a waiver of attorney-client privilege. And in almost all circumstances, in order to get the information in, the criminal defendant would have to testify, because how else would it be not hearsay unless the criminal defendant took the stand and said, the reason that I engaged in the crime, you're essentially admitting to the crime, the reason I committed the crime is because my lawyers told me to do it, or my lawyer told me to do it. Otherwise, it would essentially become a hearsay unless the defendant took the stand. But Trump says, and this is so interesting as well, and I'll go through this motion for you, he cites federal Judge Lewis Kaplan, the judge who he attacks in the E. Jean Carroll case, the judge who he says, Clinton appointee, this guy's a hack, this guy doesn't know what he's doing. So Judge Lewis Kaplan, who was the judge presiding over the two E. Jean Carroll cases, where Trump was first hit with a $5 million verdict, and then Trump was hit with an $83.3 million verdict recently. Judge Lewis Kaplan was also the judge who presided over the Sam Bankman-Fried case. And in the Sam Bankman-Fried case, Judge Lewis Kaplan allowed a very limited amount of information that kind of looked like a advice of counsel defense without having basically a full waiver of attorney-client privilege. But there are some distinctions there as well. I mean, first off, the irony, of course, of Donald Trump citing very positively here in the Manhattan District Attorney case, federal Judge Lewis Kaplan, to me is chef's kiss irony. It's hilarious, and I find it very funny. But also, Judge Lewis Kaplan did not really allow what Donald Trump claimed Judge Lewis Kaplan allowed. Federal Judge Kaplan allowed really just a small amount of information about Sam Bankman-Fried's lawyers talking about the protocols they had about document retention, because one of the things that was being shown was that Sam Bankman-Fried destroyed all of these documents that ultimately showed his intent to commit the crimes to try to cover it up. But federal Judge Kaplan did not allow some sort of widespread informal advice of counsel defense. But what else happened in the Sam Bankman-Fried criminal trial? Well, in addition to the fact that Sam Bankman-Fried was found guilty, I think he was sentenced to 100 plus years in prison, which would be a great outcome for Donald Trump. Yes, please cite Sam Bankman-Fried, Donald Trump, who got sentenced to prison for the rest of his life. I would like to go back and cite Sam Bankman-Fried for your sentencing, Donald Trump. But Sam Bankman-Fried took the stand. Sam Bankman-Fried actually testified in order to make this very narrow point about lawyers' advice regarding document retention. But it didn't go to the thrust of what the case was, and Bankman-Fried did not put forward, a real, serious advice of counsel defense, and nor did Judge Lewis Kaplan allow it. So Trump citing that case, to me, absolutely not only does not make sense, but I don't think it actually helps Donald Trump the way he claims it does. So here's Trump's filing. He goes, Donald Trump submits this notice concerning his intent to rely on the defense of advice of counsel at trial as ordered by the court on February 7, 2024. At the outset, we emphasize that there is a marked difference between the commonly referred to, quote, advice of counsel defense and the defense that Donald Trump expects to raise at trial, part of which will be that Trump lacked the requisite intent to commit the conduct charged in the indictment because of his awareness that various lawyers were involved in the underlying conduct giving rise to the charges. Then they go on to say, as Judge Lewis Kaplan recently stated, quote, evidence concerning the presence, involvement, and even advice of lawyers in relevant invest is best viewed as evidence probative of the defendant's intent to defraud or lack thereof. And then it goes on to talk about how the required element of, it goes on to say, Trump intends to elicit these facts from witnesses, including former AMI executives and Michael Cohen, whom we expect will testify about Trump's awareness of counsel's involvement in the charged conduct. This is not a formal advice of counsel defense. While Trump intends to elicit evidence concerning the presence, involvement, and advice of lawyers in relevant events giving rise to the charges in the indictment, he does not intend to assert a formal advice of counsel defense that would require him to prove at trial that he, 1, made a complete disclosure to counsel concerning the matter at issue, 2, sought advice as to the legality of his conduct, 3, received advice that his conduct was legal, and 4, relied on the evidence in good faith, as you would be required to do in an official advice of counsel defense. Accordingly, there is no privilege waiver requiring production of communications protected by the attorney-client privilege, and there's no basis for the people to demand a preview of our defense at trial. So it's just Donald Trump again being very, very squirmy and basically saying, well, he previously said, number one, I have absolute presidential immunity even before I'm in office, because these crimes took place before he was in office. The fact that I may have engaged in a cover-up over the crime while I was in office, that should basically serve to provide the immunity for the crimes committed before. So that was the other motion that he filed. Remember, I compared that to, okay, so you're saying you robbed the bank before you were in office, then covered up the bank robbery while you were in office, and that your cover-up then shields the conduct before you were in office. It's ridiculous, it's absurd, it's beyond frivolous. But now Trump also says as well, if that one doesn't work, I got another one for you folks. Okay. Hear me out. My absolute immunity doesn't work. The next thing I'm going to do is say, my lawyers made me have sex with a porn star and make hush money payments and misclassify the records, and it's the lawyer's fault, but I don't have to prove that the actual elements of advice of counsel and show that, the lawyers, provided this information and that I had the requisite intent. And I don't want to testify. I just want to blame my lawyers for the conduct. What I like is this guy, Jonathan Martin, says, it turns Trump's attorneys into material witnesses who he would ostensibly be accusing of giving him unlawful advice, so they would potentially testify as well. Also, an advice of counsel defense is essentially an admission that the unlawful conduct occurred. Bring it on, because you'd basically be saying the criminal conduct happened and it was the lawyer's fault for giving me the criminal conduct advice and that I relied on it. Now, how Donald Trump intends to get this in on cross-examination without his own testimony, again, is citing the Sam Bankman-Fried case. Sam Bankman-Fried testified. Sam Bankman-Fried was found guilty. Keep citing Sam Bankman-Fried, Donald Trump. But again, these are just kind of outrageous defenses that someone who did it does. And we're talking about now the leader of the Republican Party. So utterly pathetic, but that's Trump's latest. I want to cite advice of counsel, but I'm not going to formally make the advice of counsel because then I have to show the elements. So judge, just let me blame my lawyers without going through the actual rules. Sound like Trump? Yeah, I thought so. I'm Ben Meiselas. This is the MeidasTouch Network. Hit subscribe. We're on our way to 3 million subscribers. Thanks to your support. Have a wonderful day.
Hey, Midas Mighty. Love this report? Continue the conversation by following us on Instagram at MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.